We continue to read the case of Roy Dessado versus Jennifer Brown. It falls under the Property Rights of Spouses Act. Submission by the parties. Attorneys at law for both parties found unison on the applicable case law in respect of the principles for an extension of time, prima facie case, delay, prejudice, and the overriding objective. For example, and it shows, it outlines some previous cases here. 1. Whether the court should grant the extension of time under Section 13 of the Property Rights of Spouses Act. 2. Whether the respondent would be prejudiced in the grant the extension of, would be prejudiced in the granting of the extension of, I think it should be, of time under Section 13 of the Property Rights of Spouses Act. Whether the overriding objective can be preserved in the grant or refusal of the extension of time under Section 13 of the Property Rights of Spouses Act. So basically, so far, as you see, if you have been in a common law relationship for 5 years or more and it broke down, and you are applying to the court for division of property and entitlement, you need to do so within 12 months. All right. We continue. After the common law union ended in 2002, the claimant, that's Mr. Dessado, averred that he was physically barred and made attempts to re-enter the family home in 2019 and 2020, some 17 to 18 years later. All right. He did so after being evicted from a house he had rented. So he rented that house for 17 years, was evicted and wanted to come back to that house in which he had lived with the woman. The claimant, Mr. Dessado, conceded that he delayed in making the application because he did not know about the 12 months prescription under the Property Rights of Spouses Act, nor did it enter his mind that he would have to apply for division of something that he is part owner. Did not know? Well, ensure that you know what the act says, what the law says, all right? So it's good that you are reading through this with me. The claimant, Mr. Dessado, did not think that the court's intervention was necessary to realize his interest in the family home and thought that his interest could be realized or determined without the intervention of the court. So you see the importance of knowing the law. Mr. Dessado claimed further, avers that his former spouse was aware that he was not forfeiting his share. So here, probably his former spouse could make a claim that he was indeed forfeiting his share if he stayed away for 17 years. Right. The defendant, that's Ms. Brown, in response to the application, avers that the delay in filing the fixed date claim form is approximately 18 years and would be considered to be extremely inordinate delay. She denies that the inordinate delay was due to her actions in 2003 of barring the applicant from entering the property. The defendant, as Mr. Dessado, says that was precipitated, that what precipitated Miss Brown, that what precipitated him seeking the court's intervention was a cease and desist letter regarding the property. She avers that the claimant, that's Mr. Desado's interest in the property would have been defeated by the effluxion of time. Why are these big words in this document? It's the passing of time under the limitation of Actions Act. The defendant refuses or refutes the information asserted in the claimant's affidavit. That means Mr. Dessado. No, Miss Brown refutes the information asserted in Mr. Desado's affidavit, pointing to several instances which suggest that Mr. Desado's assertions are superfluous, contrived, and lacks credibility. Superfluous. All right. Now, we will look at the analysis. It's a short document, so we will not skip to the conclusion. We will look at the analysis and then the conclusion.